to be delivered this afternoon, and we just want to take you in to listen in on what's happening as of this hour.
Environment and natural resources. The text and substance of the two Gazette notices is the same in every respect. The Gazette notice reads as follows, and I quote, "In exercise of the powers conferred under Sections 3 and H6 of the Environment Management and Coordination Act, it is notified to the public that the Cabinet Secretary for Environment and Natural Resources has, with effect from 6 months from the date of this notice, banned the use, manufacture, and importation of all plastic bags used for commercial and household packaging, defined as follows. A, carrier bag, dash, bag constructed with handles and with or without gussets. B, flat bag, dash, bag constructed without handles and with or without gussets. Dated the 28th February 2017, signed by Judy W. Wahungu, Cabinet Secretary for Environment and Natural Resources." End of quote. Through a petition dated 28th July 2017 and filed in court on the same day, the first petitioner has challenged the said Gazette notice and seeks an order quashing it. Similarly, through a judicial review motion dated 17th July 2017, the second petitioner seeks to quash the said Gazette notice. Together with the petition, the first petitioner filed a notice of motion dated 28th July 2017, seeking a conservatory order staying the implementation of the Gazette notice, pending the hearing and determination of the petition. That notice of motion is the subject of this ruling. First petitioner's case. The first ground upon which the first petitioner has challenged the Gazette notice is that the first respondent published the notice in contravention of Section 5 of the Statutory Instruments Act, Act number 23 of 2013. The first petitioner contends that this legal framework enjoins every authority making regulations to make consultations with the persons who are likely to be affected by the proposed regulatory instrument before making the statutory instrument. The first petitioner further contends that the notice contravenes Articles 10 and 69 sub-article 1D of the Constitution of Kenya 2010. It is the first petitioner's case that the notice contravenes the above laws because there was no consultation with the stakeholders and there was no public participation prior to the issuance of the notice. Second, the first petitioner contends that the first respondent's decision was not preceded by a regulatory impact statement prepared by the first respondent. To this extent, the first petitioner argues that the notice offends the provisions of Section 6 of the Statutory Instruments Act, Act number 23 of 2013, which obligates every regulatory authority to prepare a regulatory impact statement in instances where the statutory instrument imposes significant costs on the community. The third ground argued by the first petitioner is that Section H6, subsection 2 of the Environment Management and Coordination Act, which the first respondent invoked in issuing the notice, does not grant her statutory powers to ban the manufacture and the importation of plastic, carrier, and flat bags. Fourth, the first petitioner contends that the first and third respondents were privy to preceding discussions and memorandum of understanding aimed at creating a plastic waste management mechanism, including the imposition of a levy which the first petitioner's members were willing to pay to actualize the mechanism. The first respondent contends that the first petitioner's new policy entailing ban of plastic bags is drastic, disproportionate, and ignores other viable and reasonable alternatives that would not adversely impact on the economy and on the livelihood of many people. The fifth ground raised by the first petitioner is that by failing to grant the first petitioner an opportunity to present his case on the impact of the Gazette notice, the first and third respondents are in violation of the first petitioner's right to fair administrative action under Article 47 of the Constitution of Kenya and the Sections 5 and 6 of the Fair Administrative Action Act. The first petitioner's affidavit and submissions, both written and oral, on the application under consideration, canvass and advance the above 5 grounds. In addition, the first petitioner argues that plastic is an extremely cost-effective, versatile, and durable synthetic product made from oil byproducts, which is used across diverse sectors, including packaging, construction, transportation, healthcare, and electronics. In urging the court to grant a conservatory order, the first petitioner argues that the impinged regulation will cause a virtual collapse of the sectors affected by the ban and will occasion a devastating, unquantifiable, and irreparable loss to the affected sectors. The second petitioner supports the first petitioner's case for a conservatory order and advances largely similar grounds. The second petitioner further contends that the wording of the notice is ambiguous and constitutes a total ban on all plastic bags. First, second, and third respondents' case. The first, second, and third respondents strongly oppose the plea for a conservatory order suspending the implementation of the legal notice. Their case is that the notice was properly issued under Sections 3 and 86 of the Environmental Management and Coordination Act, that is Chapter 3, H7, hereinafter referred to as the EMCA. I'll abbreviate it to the EMCA henceforth. A legislative instrument enacted to provide regulatory legal framework on all issues relating to the environment. They further contended that the notice was issued pursuant to the administrative powers vested in the first respondent. They contended that under Article 42 of the Constitution of Kenya, every person has the right to a clean and healthy environment, and that this right includes the right to have the environment protected by the state for the benefit of present and future generations. They further contend that Article 67 of the Constitution obligates the state to ensure sustainable exploitation, utilization, management, and conservation of the environment and natural resources. They further contend that Article 69 enjoins the state to eliminate processes and activities that are likely to endanger the environment. The first, third, and third respondents further argue that Article 69 of the Constitution requires every person, including the petitioners herein, to cooperate with the state in protecting and conserving the environment and ensuring ecologically sustainable development and use of natural resources. The first, second, and third respondents enshrines in the Constitution the precautionary principle